position.
Yes.
Is entirely different, right? Contributory provident fund, as it originally stood, means there are contributions by the employee, contributions by the employer, interest, bonus, etc. A general provident fund does not contemplate a contribution by the employer or the authority. It's only my contribution as an employee. Now, therefore, today, as a district judge, I did not have a general contributory provident fund. I'm only contributing a contributory provident fund, not a general provident fund.
Question, Mr. Attorney.
Yes.
You said that the transfer of NPS contribution into GPF account is not permissible.
It's not permissible.
Okay. For the time being, let us proceed on that foot.
Yes, yes.
What will you do with this NPS?
Exactly. That question is certainly, I was trying to understand that question.
Okay. Is it your argument
Yes.
that if it is not permissible to transfer it to general provident fund, is it permissible to transfer it to the contributory pension scheme?
No, it already belongs to the pension fund.
So it remains as
it will remain, either it will remain there or it can be given back.
It can be given back to the concerned officer.
Yes, yes.
But your argument is that in any event, after his elevation as a High Court judge, he cannot open a GPF account.
Because the Act itself provides for it. The Act says, let's close our eyes to the pension fund scheme, as if there is a contributory provident fund scheme in position. Section 20 contemplates two different classes. A judge who is appointed the High Court judge will have a general provident fund.
See, Section 20 doesn't apply.
Kindly see, in the context of Section 20, it has happened. Their assertion was in the context of Section 20.
Okay, what is the problem if the NPS contribution is given to them on their elevation? GPF account can always be opened. The only problem is your argument is that they have not contributed anything. So that would lead to some financial implications. Are the financial implications coming that way?
Therefore, the question is,
the whole thing boils down to only one thing: financial implications.
Not only financial.
To avoid to overcome the financial applications, should we draw two sets of judges?
Let us try to look at it differently. I understand. I'm thankful to Ross for this. But the question is, if under Section 20, as I read it, if two distinct classes are contemplated, because of the pension scheme,
for the purpose of provident fund.
Correct.
For all other purposes.
If I am a contributory provident fund class, I continue to belong to that class, even after appointment to the High Court.
There is no contributory.
That's what Section 20 says.
There is no concept of a contributory fund.
There is no provident fund.
There is no concept of a contributory provident fund. Let the Attorney General show one piece of paper, Milots, where
today we are not.
You are repeatedly saying contributory provident fund. There is no concept of a
contributory judges, right?
Yes, there is a concept of contributory provident fund.
Yes, yes. 1 minute.
There is.
Show it.
No, there is a contributory. The section talks about a contributory provident fund.
Show us that there is a contributory provident fund for district judges.
There is not.
There's nothing like that.
I will show that. I'll try to show that. What I'm trying to say,
there is no contributory provident fund for district judges at all.
I'm only trying to read Section 20. Section 20 contemplates a contributory provident fund.
No,
it contemplates.
No. It contemplates a provident.
The proviso contemplates. Kindly see the proviso.
It speaks of provident fund.
No. Kindly see the proviso. Let us forget that. Read Section 20.
The main part, every judge.
Read Section 20.
Yes, every judge shall be entitled to subscribe to the general provident fund.
Provided.
But proviso will have to be read in context with the main provision.
Provided the proviso says
disjunctive of the main.
No, the proviso. What does the proviso say? Why is the proviso there at all? The proviso contemplates a class of judges who will be appointed as High Court judges who contribute to a provident fund, which so and so before appointed as a judge.
In terms of the proviso,
there was today this provision has undergone a change. That's what I'm trying to point out.
This provision has not undergone a change. Section 20 remains as it is.
It's undergone a change because judges are contributing to the pension fund.
Mr. Attorney, one line, and perhaps you may be able to enlighten us.
Yes.
Just see the proviso. This is exactly what has fallen from my Lord the Chief Justice,
Continue to subscribe to the Provident Fund.
to which he was subscribing before his appointment as a judge.
Correct,
The
correct.
words are to which he was subscribing before his appointment as a judge. Proviso only clarifies that he shall continue to subscribe. But you have to first convince
The
us,
problem has arisen today. Yeah, sorry.
every judge shall be entitled to subscribe to the General Provident Fund. No,
I entirely agree, sir.
show us that they
I'm
had
not saying no to that.
Show
But
us.
the problem today is something else. The
Well,
problem
just
today
one
is
second.
something else.
Mr. Attorney, just one second.
show us that they had subscribed to the General Provident Fund.
I can't alter the text of the
That's-
provision.
and we-
I'm not doing that.
Look into
I'm
the
not-
right-
It doesn't apply.
I'm
Provided
not doing
it
that.
doesn't apply.
Please appreciate this difficulty. The difficulty is in prayer here they say, shift all our pension contributions in the pension fund to the general provident fund account. That is their prayer. The section does not contemplate.
Okay,
That we may or may not
transfer
grant.
it.
Yeah,
Then
that
transfer
we may not
it.
grant.
Give
We
it
don't-
back to them. Give it
We
back.
can give it back to them.
Okay, give it back to them, but you can't deny that, sorry, we will not allow you to open a GPF.
No, they can open a JPF account today and start contributing.
Mr.
Problem
Parmeshwar,
fund.
the issue
But
of
our problem with
transfer-
that-
Just one second.
Yes.
The issue of the transfer of the contributions from the pension fund, from the general provident to the general provident fund is a slightly different issue. What we can direct is, once they become judges of the High Court, a general provident fund must be opened in their name, right? And post their appointment as High Court judges, they must have a GPF. All right. Before their appointment, there was no provident fund at all. Therefore, once they were appointed as judges of the High Court, a provident fund must be opened, and all contributions must be made like any other bar judge thereafter.
I have two
No
answers.
difficulty at all.
Perhaps what is in your mind is, whatever has been accumulated in NPS,
It must be-
if it goes there, it will yield something more.
No,
That's precisely
Tell your lordships, I
That will amount to altering the text of the pension fund.
what we can do is, Mr. Parmeshwar, NPS amount, we'll ask them to give you back and we'll direct them to permit them to open a GPF and
Very
start afresh.
Very well. In fact, we know the Bihar letters, my lord, government letter, P7 and P8 says so, my lord.
I have no difficulty.
P7 and
I
P8
only
says
wanted
All
to.
right, now we'll dictate this. Chalo, ye le lo.
No, Your Worship may give me only 5 minutes.
Wait a second.
I'll make some.
You know, you don't understand.
In this very matter.
We have to at least finish what we can right now. Please,
Let me help you,
we will not be able to finish anything.
And
Let's help.
lastly, Mr. Lordship may only observe that the retirement benefit, entire retirement benefit of the judges, my lord, who are appointed for judiciary, my lord, should be at par with the High Court judges appointed for the bar. The entire retirement benefit, my lord.
Just wait for the judgment to be
Very
declared.
well. I'm sure.
So this will govern writ petition number 3 writ petition there, 232 of 23, 3 of 2024, and 1262 of 2021.
No, 1262 is Mr. Dwivedi's matter.
That will keep separate.
That's right. So these two are the only ones concerning Provident Fund, your lordship. First,
Yes. Invoking the jurisdiction of this court under Article 32 of the Constitution has been invoked by how many judges totally?
8 sitting judges. 8 sitting judges of the Patna High Court.
Both the matters together.
Yes, my lord. Seven judges, my lord, in 232, and 1 judge in petition number 3, my lord.
All right. By 8 judges of the High Court of Patna who are aggrieved by a communication dated 13 December 2022 issued